There we go. Good morning. Welcome. It's nice to see everybody in person. It's been a couple of years, so we've had a couple of virtual Zoom annual conferences, so it's great to have you and the representation that we have today. And for those that of our members and delegates who are not able to be with us in person today, we appreciate the generosity of John Knox Village, Pompano Beach. They're going to record Dr. Pearson's session, so we can share that video link with members who were not able to be with us in person today. So we're grateful for that. It's been a number of years. I think the last time that Dr. Pearson was with us actually was also in this region. So we had at that time it was at Edgewater Point Estates in Boca Raton. It was the last time that she was with us, and great to have her back as our first in-person meeting in the last couple of years. So most of you hopefully have read her bio, but I'm going to do that for the people who are not with us today, and then we'll have her come up. So we're great to have her. So Catherine Pearson is a professor of law and the Arthur L. and Sandra S. Picone Faculty Scholar at Dickinson Law, Pennsylvania State University in Carlisle, Pennsylvania. Her scholarship focuses on laws and policies connected to aging, and she frequently includes age-related issues in her teaching of courses on contract law, conflicts of law, and nonprofit organization law. During the fall semester of 2018, she initiated a new format for her elder law course, with individual modules permitting in-depth examination of selected financial planning, care planning, which includes end-of-life decision-making, and comparative law issues. She's the author of articles and chapters on long-term care and continuing care communities, financing, and other obligations. And she's also the co-author of a treatise, The Law of Financial Abuse and Exploitation. As a former U.S. Fulbright Scholar in the UK in 2010, her work includes international comparative analysis of laws affecting families, including work as an international consultant to promote better systems for safeguarding adult social care. And she's a frequent writer for the Elder Law Professor blog. Our work with her over the years primarily has been focused through other state continuing care retirement associations that she's been a great resource to, certainly at the national level with the National Continuing Care Residents Association, where she's been a frequent author and speaker for them and consultant, as well as her work with the U.S. Special Committee on Aging, that focused on continuing care retirement communities back in 2010. So she's no better person to talk about this topic this morning about resident engagement and community governance than Dr. Pearson. So we're grateful to have her back with us today, and welcome to Florida. Thank you.
Well, thank you so much, Bennett and Lauren. Both of you have made me feel so welcome and so well organized getting here. It's wonderful to have the professional people to work with FLiCRA. Many states, most states, almost all of the other states have nothing like that. So once again, FLiCRA is a leader in having an organization that has the capability of, delivering on their goals when it comes to legislation, when it comes to important issues that affect the entire state. I have to say, it's really a breath of fresh air for me to be down in Florida for many reasons, including the fact that I'm coming from Pennsylvania. This has been a difficult election season in Pennsylvania. I feel a little bit like, maybe like Judy Garland escaping over the rainbow. I've just escaped from the land of Oz. I've also want to thank so many people who've been so kind to me after I arrived here. Probably right on the top of that list is Jackie Bayer and her husband Dave, but particularly Jackie. She's made me feel very much at home. We've had great conversations, and we've got plans for the future, I can tell already. Diane Dalsimer, am I pronouncing your name correctly? Dalsimer, and your husband, John, who I met last night at dinner. It was so lovely knowing that both of you will probably have continuing connections to FLiCRA, even as you're smiling, I thought, an awful lot last night, because I learned that you were leaving your current post as president. Those kinds of changes are important in the world of continuing care and in the world of leadership as well. Well, as many of you, or some of you at least might know, my journey to today really began because I used to have an elder law, we called it an elder protection clinic at Penn State. Actually, it wasn't even Penn State back then. It was before there was a Penn State. But the Dickinson School of Law, and we merged with Penn State in 2000. And in about 2004, a group of residents from a continuing care community in State College, my location is actually not in State College, even though I'm with Penn State, and State College is the home base for Penn State. But I'm down in Carlisle, and these people drove down to meet with me and some of my students to talk about what they were concerned about. And I had never heard of a continuing care community before that date, even though by that time I probably had been teaching elder law as a subject. Maybe I'd heard of it, but I hadn't thought about it for about 10 years at that point. And they sat down and talked to me about how they could not find legal counsel who understood what continuing care retirement communities were, that they couldn't find legislators who understood what they were, and more importantly, they couldn't find the regulator at the Department of Insurance at all. And so they asked me for help, and so my students and I began to dig in. And one of my early, this is one of my early stories, I've said it many times, but it's worth repeating. I went to the Department of Insurance in Pennsylvania in an attempt to meet somebody who was on the regulation side. I was unsuccessful, but they said, we'd be happy for you to look at the annual documents that each community in Pennsylvania, and at that time we had 160 communities in Pennsylvania, file with the state every year. So I said, that'd be great. And so they rolled them out on carts and carts and carts. And that's when I realized a significant point. None of the seals on those documents had ever been broken. The Department of Insurance was not reading what was being submitted. So that was my kind of first, okay, there's something to think about here moment. That led to my first article, and at the time, in fact, there are a lot of mistakes in that article, but, probably productive mistakes, I'd like to think. And that article, I think I called it something like Continuing Care Retirement Communities, State Regulation, and the Importance of Lawyers. Actually, I said counsel. I knew better than say lawyers. The importance of counsel to residents and their family members. And it was really a bit of an admonition. I published it in a bar directory, a bar journal for practicing lawyers, because I could not find, even though we had a robust elder law group in Pennsylvania, I couldn't find people who understood continuing care retirement communities on the resident side, what should be the resident side, of an elder law association. And so I was kind of advocating to them about why they should know about this. And over time, that has worked. I definitely have colleagues who are lawyers and law professors. In fact, you have a law professor, former law professor here, who's worked extensively in law, in elder law. Marilyn, I see you here in the audience. She was at Rutgers. But over time, I have found more lawyers and law professors who are willing to tackle this concept. Of course, along the way, I realized when I made those mistakes in that first article, I needed to know a whole lot more about not just the concept of continuing care retirement communities, but broad areas of law that are embedded in the concept. I'm an old-fashioned, probably, in fact, definitely, trial lawyer. And so most of my career before I became a law professor was as a trial lawyer. I really didn't do transactional work very often. I used to joke that the only reason I would ever be on a contract is if it was already broken and I was litigating something. But I ended up, as a result of learning about continuing care communities, I decided I needed to teach contract law. Because when you teach something, you have to keep breaking it down so that you really understand contracts, or whatever the topic is. And what I wanted to understand was, how could it be that residents and communities were entering into a contract, which is normally a legally binding document, but in some communities, the promises were not being honored on the part of the community. Not the residents, they always had to honor their contracts, but on the part of the communities. I wanted to know why that could be true. And over time, I learned some of the reasons why, and I'll talk about them. Second, I ended up teaching, I should be teaching it today, as a matter of fact, but I gave my students a day off. I teach a course on nonprofit organizations law, because so many in the senior living space, providers in that space, are nonprofit organizations. Most hospitals, as well. And so I wanted to understand how things that looked and functioned a heck of a lot like a for-profit business are or could be nonprofit. And that's why I learned that there are some very special reasons why continuing care communities have a space in nonprofit law. I'll talk about that a little bit. Eventually, all of my work began to deal less with lawyers, thank God, and more with residents, even more, thank God. And I began to be invited to FLiCRA in its early days. Charlie Polk, I was trying to remember his name earlier, and one of the residents of his former community, or of community nearby at least, reminded me of his name. I got to know some of the early leaders in continuing care regulation. And I continue to find out interesting facts all the time. And so in the financial crisis of 2008, 2010, I was asked by multiple different people to start thinking about what I should say if there was going to be a hearing about continuing care communities before the Senate Special Committee on Aging, Senate Special Committee on Aging. And that year I was actually working in Ireland. I was actually in Northern Ireland at the time, which of course is technically UK, not that some of them will admit that. And while I was there, I really had time to think about this and began to really do a comparative study of different laws and policies among the US states. And one of the things I came to the conclusion of was there should be a national standard, and I know why there isn't, and I'll talk about that. But one of the things I ended up advocating for before the Senate was that there should be a national Bill of Rights for residents, a national template for Bill of Rights for residents. There is such a thing for nursing home residents, a national Bill of Rights for nursing home residents, but, it's a harder row because of legal reasons connected to financing as to whether Congress can enact a law for individual communities in individual states that don't have a direct Medicare or Medicaid federal spending connection. I knew that it would be unlikely there would be a federal, a national Bill of Rights, but I think the reason why I was going to talk about it anyway, and I've continued to advocate for bills of rights at legislative levels, is because the very fact that you're having that conversation is about the fact that residents are not being heard when they need to be heard at key moments. And, so I am going to continue to ring that bell. In fact, at one point, I used to laugh. I rang it so often that Larry Mannix, who used to be the head of what was now called Leading Age, I ran into him one time at a theater in Washington, D.C., and of course I knew him. I thought he might know who I was, and he kind of lit up when he saw me, and so I walked over and we were chatting, and then he remembered who she is. He could not get away from me fast enough. And so I had to laugh at that particular moment that I'd already knew that I was going to have to enter my own continuing care community under an assumed name when I'm ready to go. When I spoke before Congress, before the Senate, my title of my speech my title of my first article was The Importance of Counsel for Residents and Their Families. My second article, which was really that speech, was the importance of resident voices at continuing care communities. And over time, as you're going to hear, that has evolved as to how I view those concepts. In fact, really what I think is the important thing now is the power of resident voices. The power that you've assumed at FLiCRA, that you've made effective at FLiCRA. That's so important. I'm going to talk about 5 themes. I'm not going to go on at length because what I'm going to do is I'm going to speak a little bit and then I'm going to open it up to questions, answers, and comments. Because the most important part about voices is a dialogue. Hearing your voices, not hearing mine. The 5 themes I'm going to talk about today, 5, not 5. First of all, enforceability of rights and obligations. Not just the fact that you have rights or obligations, but the enforceability of them. Second, the very real need for connection between residents and communities and legislators and regulators. Third, have goals. You already know that. This FLiCRA is the model for having goals for what you want to see accomplished in the world of continuing care organizations, operations, and where necessary, legislation. Number 3, understanding contracts. I always say, the reason I teach contracts is because that document is the Bible when it comes to the starting place to talk about what residents have as rights or don't have as rights. And I'll talk briefly about that. And then finally, my 5th topic is about something that really organizations such as NACRA, the National Continuing Care Residents Association, and FLiCRA have really helped to promote, and that's the concept of nonprofit operations of continuing care, which I hope to see continue and thrive and not dwindle, because I still believe that nonprofit communities are the way to go. I like it, fine, everybody can have their own thing, and for-profit's good too. But I really hope that we continue to see nonprofit communities because they have a special place in the community in the United States and probably in my heart. So I'll talk about that as well. Okay, so let's go back to the first one, enforceability. So it's one thing, as in the Nursing Home Bill of Rights, that was passed, I think, in, if I'm remembering correctly, 1980s. And it was part of a spending bill. And it was directed to the fact that nursing homes are largely funded by federal dollars under Medicare and Medicaid. And they adopted a series of very clear, and you'd think they were common sense, but gee, common sense in legislation. Statements of what, residents of a nursing home had the right to, such as freedom from restraints. And not only physical restraints, but chemical restraints as well. But the statute did not build into the federal law a mechanism of enforcing that right. And so it was up to the states to adopt their own enforcements by statute or by common law, case-made law, court-made law, and that's been problematic. It ends up mostly being about malpractice in nursing homes rather than change. And so one of my early lessons was if you don't have enforceability of a right, whether it's by contract, back to that theme, or otherwise state law, it may be that you can't enforce rights or obligations, either one. It's important because right now even, next week, a week from last Tuesday, so this coming November the 8th, there's going to be a U.S. Supreme Court case that hears whether there is an implied right for residents of nursing homes to bring a civil rights action to enforce things such as freedom from restraints. I anticipate, sadly, that will be denied, that right. Because right now, the Supreme Court does not want to expand the world of what are called implied due process rights. I hope I'm wrong. I really hope I'm wrong. I've been wrong before, and I'd like to be wrong again on this one. But that's one of the things that reminds me that there needs to be enforceability if you have any form of rights or obligations. Okay, second, talking about connections between legislators and regulators. So in the early days when I was working on continuing care concerns in Pennsylvania, I'd spent a couple years doing that frustrating years, there was a regulator at the time who I had never heard his name. Nobody had ever even mentioned him to me while I was working on this, until I wrote the article, and he called me up and said, "Why didn't you interview me?" And I said, well, I'd never heard your name before. And he said, well, I'm the person at the Department of Insurance who is in charge of continuing care retirement communities. First news I'd heard of it. I said, well, great. I'd like to interview you now for my next article. That was almost the last time I heard from him. And so one of the things that residents have done much more effectively than a gosh darn law professor in, Carlisle, Pennsylvania, is organize in numbers in your community level, in your regional level, in your state level, and as necessary on a federal level. But really on a state level is what's so important. To share concerns, recognize what your goals are as state goals, and then have a plan for how you're going to address that. And that's where people like Bennett is so important, because he knows the pathway to effective legislation. And boy, I wish I could, duplicate that in every state. Right now I'm working with a group in Washington State. They're struggling with their second round of trying to get a resident-focused regulations, state law and regulations in their state, and it is a struggle. And in fact, right now, we were going to bid on writing a draft of regulations, or at least write a draft of an article about regulations, but there's 4 of us right now, and we've decided to write a separate article. And part of the reason why I love to come and meet with all of you is I'm always gathering information for this next, and probably it's going to be my last big article on CCRCs. The writing group involves myself, a resident. Many of you know Jack Cumming in California. I see people nodding their head. He's a born advocate. And he also has the advantage of having financial common sense and being a person who does the kind of financial analysis necessary to run CCRCs. And so he and I are very good friends. So he's 2 of the writers. The other 2 I can't tell you yet, but they come from the provider side. And we have realized over the, more than 20 years, almost 20 years, close to 20 years, that I've been working on continuing care communities, we've realized we actually agree more often than we disagree about resident rights. Not that the provider side can always say it publicly. And so I think that what we'll end up writing, I think the conclusion we'll end up saying is that the growth of continuing care communities will depend upon the ability of residents to continue to have a powerful voice, because that's what makes them unique. That's what makes them responsive. That's what providers should cherish, because the best salespeople for, continuing care communities, as I'm sure, our own community knows right away, is to have them talk to other residents, right? A prospective resident talks to a current resident, and they're going to tell them, A, the truth, and B, how great it is to be in a community that plays to strengths of the residents and provides care as necessary, but keeps people engaged, active, volunteering, and having a wonderful place to live. We were doing this last night at dinner, weren't we? I'm looking over and seeing another person I had dinner with last night. I mean, that's what we spent the whole dinner doing, was talking about why continuing care as a concept and as a mission works. So part of the task here is that goals portion of this is to stay in touch with community leaders and legislators and regulations. Let's see here. So one of the goals, my third point was on goals. One of the tough goals was something I advocated for early when I was talking about a national Bill of Rights, and that's the notion that residents should be members of boards of governance, have a position as on boards of governance. Leading Age definitely reacted to that. And some states, New Jersey is the leader. New Jersey passed a law. Again, residents, they were the leaders on this, not a law professor. New Jersey residents went out there and said, let's get this done. And their legislators and regulators listened. And so they have a statute that mandates that boards of directors of continuing care communities have resident voting members on their boards. And at first, sure, it was controversial at first, but over time it's really changed as a practical matter into not just one voice, but two voices, and in some cases 3 voices, and a plan for continuity. Why? Because they recognized as members of the board that they were getting additional valuable information, something that maybe they would hear about as gossip, but now they were hearing it directly so that they could test the waters for what was important and what was not important. Remember, boards of directors, they have a wonderful, important role in the operation of both for-profit and nonprofit, particularly nonprofit, but they're really the ones that need to hear so that if there's a hiccup on the management side, the provider-run side of the operation, that board of directors can say, time for a little mini course correction here. And so I still think that membership on boards is important. But what you've done in Florida is also important. I think you recognize that it's a hard fight when you have opponents of members on boards of directors, and Leading Age does not, I don't know if they support it, but they definitely oppose it at times. And you've worked to create other pathways so that there are effective communications between resident organizations, resident councils, and the leadership on the provider side of the community so that real information is being exchanged and answers given. All the litigation that's happened in the world of continuing care that I've watched, and in some cases watched daily, has been because residents had a concern and they were ignored. I started out as a litigator, but if I never litigate another case, I will be happy. I would like to see it never need litigation. I would like to see, effective communication channels happen. And more I'm seeing that because of the power of residents being effectively, presented, and people being willing to talk to each other and concede. Sometimes you have to concede on either side to get something done. Heck, Washington doesn't understand that. But it's important to know when is the right moment to press and when is the right moment to say, okay, that battle will remain for another day. So you understand creating new goals if the first goal doesn't work. My 4th point was about contracts. So one of the things that I encourage state organizations to do, and many states have done it, I don't know actually if Florida's done this, is collected contracts from your communities and compared them. Because what you're going to find are different ways in which the contracts work. Some states have even provided a written guide. The residents themselves have provided written guides to help future residents understand the contracts and what to look for. And these days, one of the things money is money, that's one thing to look for. But what I look for is there a unilateral right on the part of the provider to change the contract terms in the future without a new contract? So keep an eye out for that, because that is the way that changes are made in ways that tend to frustrate residents. A good community won't do that. Many communities won't do that because they just recognize that's a way to start a fight that they don't want to be engaged in. So they'll automatically involve community members, but not everybody. There are some communities that will change the terms after the contract is written, and really that shouldn't happen, but the way in which it happens is if there is that power written into the first contract with the resident, or remember too, communities have sequences of contracts. So the contract you signed may not be the contract that somebody signs 10 years later. And so you need to keep an eye on what those changes are in that way across the board as well. So understanding contracts. Gee, a lawyer saying understanding contracts. Wonder why we say that. We're usually the ones who've written them. That's why. My 5th point, my last point, is something that I've only recently started talking about publicly. And that's the role of nonprofits. So the federal law is why many nonprofit continuing care communities exist, because there is a way to avoid all federal income taxes and also be grandfathered into an exemption from all state income taxes if you are recognized as a 501c3 charitable organization. And the word is a charitable community or charitable organization. The definition of charitable is not clearly defined in the federal tax law, and so it's become a bit gray at times. And over time, there was a series of Internal Revenue Service rulings called private letter rulings or public letter rulings, depending on which they were, that began to expand the concept of charitable in the context of senior living. It used to be that the contracts had to provide for life care, period. If you ran out of money, they still had to provide that care. Now that's not required. And now you can still be a 501c3 organization because you're providing quote-unquote housing and services for an at-risk community of older adults. That continues to be true. And you're doing it at a reasonable price. That's somewhat of an issue at points. But there's no longer that absolute obligation to provide lifetime care. And part of that is a structural financing reason. I totally understand that. You know, I think I probably hear from as many residents as I do providers about whether there's been an adequate financial analysis of prospective residents. Will they be able to pay for their care? But I'm going to urge something a little different. I'm going to urge residents to say, shouldn't we be thinking about having a charitable mission that brings more people in who may not be able to pay 100% of their care, and we know that from day one? Isn't that in the very nature of charitable care that should entitle us to a tax-exempt status? I'll tell you one of the reasons to think about it at the federal level is because states have already started thinking about it. State laws, and particularly the biggie these days is property tax laws, or use laws, or sales tax laws, have recognized that if what they call now, they have a requirement, sometimes it's called a purely charitable mission. And so continuing care communities in the nation, including Pennsylvania, have been challenged as not being sufficiently charitable in order to qualify for that state tax exemption. And the people who are on the charitable entities law professor side say, someday IRS is going to take a hard look at this as well. And at periods of time they have. There's been, sometimes they would set up a hearing, and that's when leading age really does do you a favor. They stepped in quickly and shut that down to prevent even a hearing on it at that point. But in the search for tax dollars, which goes on at the state level, the community level, and certainly at the federal level, you've got to keep an eye on that. So my most recent article was written with a bankruptcy attorney specialist, friend of mine, Douglas Rader. And we wrote it, and we called Putting More Charity Back into Charitable Organizations. And really what we ended up examining was a community that was not registered as a continuing care retirement community in Pennsylvania, but in essence that's what it was, except for one big factor. They were not providing any charitable care. They were a 501c3, they were not a CCRC, they had phased care, they didn't have any promises of lifetime care, and they were kicking people out if they couldn't pay. And not a lot of people out, and some people would leave before they spent down their assets because they were frightened about what would happen to them. And I understand why, just because you run a charity doesn't mean it's free. That's not what charity is, right? It's about a plan. But I do think that some of the strongest communities I've seen in the 20 years I've been doing this are the ones that have a charitable mission that they've defined, that the residents support, the residents understand, the residents don't fear that charitable care. And you know what it ends up being for the providers that have figured this out? It ends up being a boon to that organization. Why? Because that charitable mission means that residents will leave part of their estates, and sometimes all of their estates when they pass away, back to the community that provided them those great, 20 years towards the end of their life. One of the places I visit regularly is Masonic villages of Elizabethtown in Pennsylvania, and they have part of their communities that are developed to charitable care, people who have never paid beyond, a minimum amount from their Social Security for their care. Why? In their case, it's because they were Masons or Masons' families, so that mission is from the Brotherhood itself. But that same type of a mission could exist for any nonprofit organization that really cares about that. So that's something I just think, I'm starting to advocate. It's something that organizations should think about, and state organizations that want to see continuing care thrive as a nonprofit entity should also think about more concretely. So those are my 5 big points. I'm sure I'm running short on time. Well, I'm not too far back. Okay, so those are my 5 points. Now I'm going to just do some kind of small points. One of the challenges in the world of all of commercial enterprises, including Penn State Dickinson Law, I always have to look on the website before I go to make a speech. What is our brand market name this week? Because I can never remember. Well, I think that's one of the challenges. I certainly understand why Leading Age led the way in changing from continuing care retirement communities to life plan communities, because that's, a more positive way. The challenge is we still need to have people be honest with themselves, about what the benefit of a CCRC is, whether you call it an LPC or a life plan community, or, you call it any other name. And, I think that's, again, where residents have a public mission that they deal with in private. When they see new residents coming into their community, they talk about the advantages, right, of living in a community. But my gosh, you could do more. You could talk publicly about the advantages of living in a continuing care community. You can become advocates beyond the space of just your own community. What I'm going to do now is I'm going to stop my formal remarks. I'll wind them up. And then what I'm going to do is open it up to question, answers, and comments. So think about that. Start thinking about what you want to talk about, and I'll just close in this way. So last night at dinner, we were talking about what we all liked about continuing care communities. We actually started talking about what we like about the greenhouse movement. We were talking about positives in the world of what's called senior living. And I realized that we were sitting around in our little group and we were preaching to the choir, right? We all agreed. We were preaching, but we were preaching to the choir. And so as I've talked about the importance of counsel for residents, I was unsuccessful with that mission. There's a few lawyers who know about CCRCs, but I've kind of bombed on that mission of my own. And then talked about the importance of resident voices. Now what I'm doing is talking about the power of resident voices. And that's why it's your turn to speak.